you very much, and welcome, I presume, since I seem to be the first speaker. So, on behalf of the organisers, it's great to have you here. I am a mediator. I'm also a barrister, senior counsel, and for 2 years, between 2012 and 2014, I was chairman of the bar. And one of the things that struck me during that period of time was that people were turned off by litigation. And litigation is seen to be a very expensive and prolonged process, but it is my bread and butter, so I'm not going to entirely diss it. Nonetheless, when you look around the litigation world, you see that over the last 10 or 15 or 20 years there's been a big push to try and find alternatives to the lengthy form of litigation and the expensive form of litigation that we carry out in the common law world. And it's in that context that I started getting interested in mediation. One of the things that, these are one of the classic sort of phrases that keep being used in relation to mediation, namely the benefits of it. And Carl Rogers is a well-known psychologist, and it's as if we're in an airport, really, isn't it?
Construction Summit. I would like to invite all of the exhibitors, speakers, to the main stage at the rear of the hall to hear from Damien English, Minister for Housing and Rural Affairs.
How do I compete with a government minister, really? Anyway, therapeutic relationships. So that might sound a lot of guff, and to a certain extent it is, but I don't know, have many of you been actually involved in a mediation? Anybody in the room? Okay. Kate has, but nobody else. A mediation, so that I can try and describe it to you, a bit like an elephant, is a one-day event. And it's a one-day event where the parties to the dispute, and since we're in the construction world, let's talk about a construction dispute, have agreed that instead of going to go to court, that they will appoint an independent person who will act, in essence, as a moderator in the course of a day, a full day, for the purposes of seeing if the dispute can be settled between the parties. So the mediator is not an arbitrator, not a decider of fact, but is a facilitator and somebody who moves, in essence, very often from room to room to room, bringing proposals from one room to the other. Now, that only works if the parties want to solve the dispute. And I suppose one of the things that those of us in the mediation world realise is it is remarkable how successful in all types of disputes, but particularly in construction disputes, how incredibly successful it has turned out to be. And I'll show you some stats later. And here's a sort of a comparator of the various areas, and if I can just step back and just comment on them. You can see on the left-hand side the litigation, what they do in litigation, and what we do in mediation. Litigation is a battle, where you have lawyers, barristers and solicitors on one side, you have lawyers, barristers, solicitors on the other side. Witnesses are called, witnesses are examined, witnesses are cross-examined, evidence is adduced, and the whole format is very legal, it is very court-centric, it is very lawyer-centric, and very often the interests of the clients get lost in this particular process. One thing that we find about mediation is that the clients are there. The clients have their say. A good mediator will get to know, not the lawyers, but get to know the clients in the course of the day. And that they feel, and they are, very much in control of the process. So consensual by agreement. Nothing is forced on the parties. It is something that actually is agreed between them. And therefore has a far likelier of being successful and of holding itself. It's voluntary, nobody's forcing the parties to go to mediation, although the rules of the courts now are advising parties of mediation more and more, and we're seeing more and more judges suggesting have the parties considered mediation. And it's one of the factors ultimately where costs orders can be made against parties who haven't considered mediation. The cost of a mediation itself is remarkably cheap. We're talking for a day, a complex matter of maybe 3, 4, or 5 million euro. The mediator could be something between 5, 8 to 10,000 euro for the day. That's it. Then you're only talking about the rooms. And who comes to a mediation? Generally you advise lawyers, but the clients, the decision makers, are the key people who should be in the room, who should be available. So there's a whole list of other issues that arise in mediation, but perhaps one of the one that I've found the most useful is that at the end of a mediation, it's remarkable how the business relationships between the parties continue. Very, very seldom do you find after litigation that the lads go for a pint afterwards, or that they continue to work with each other afterwards, or that there's any interaction between the companies one way or the other. They will say, I will not do any work with that party who litigated against me and made my 2 years misery for me, and I lost money over it. So with a mediation, there's a far greater chance of a future relationship and of matters not reaching the hothouse approach that very often occurs in a courtroom. Now, how do we get to mediation? Well, very often the contract will set out that mediation is one of the matters that they should consider. Very much like an arbitration clause, it can be there, it can be ignored. It sometimes doesn't have the impetus or the real smell of success when it's just printed in a form. And so therefore I would urge all of you who are anxious to try and avoid litigation to get to know what a mediation is. And you can go online, and there are quite a good number of programs and on YouTube and matters of that nature which will actually give you a flavour of what a mediation looks like and feels like. So by agreement, by direction of court, and then you get round to the choosing of a mediator. That can be a very tricky area. There are a number of websites. The Bar Council has a website, the Law Society, and CEDAR also has a website. And you will find, generally by rule, by word of mouth, who are the good mediators, who are the bad mediators. Very often somebody with great qualifications doesn't make a good mediator. One of the key ingredients of a mediator is the ability to listen, and also the ability to get on with people. Because if you don't like your mediator, the chances are you're not going to settle the case. Notwithstanding the mediator has nothing to do with the case. It becomes an impediment or an irritant, or she isn't really listening or isn't understanding the issues. And so getting a right mediator is key. And very often what I've heard from particularly insurance companies and banks who've gone to mediation, they said, we just had the wrong mediator. I'm in favour of the process, but our experience wasn't good. So getting the right mediator is a key issue. Now, who attends, I've sort of gone through this to a certain extent already. The key decision makers. Very, very often we find the MD isn't there. She's at a conference, she's not present, she can't be here, and thus we can't settle the case. The parties can't settle the case because they have to go back to base camp. They have to go back to the MD or the financial director who isn't in the room. And if they're not there, if they haven't invested the time, effort and energy to be there just for one day, well then there is a problem. And so the key decision makers must be present from both rooms. And very often they go and settle the case with the facilitation of the mediator or the parties. Lawyers are obviously helpful because if it's going to be a binding agreement, well then you do need lawyers to be there. The mediator does not draft the agreement, doesn't advise on the agreement. That's not the role of the mediator. The mediator is there to facilitate the parties. First thing mediator says is a general meeting when everybody's in the room, I won't be deciding this case. It's not my role, it's your role, and it's up to you. And I won't be advising you in relation to the legal efficacy of the agreement. Again, that's your role. But anybody else can come. Generally, depending upon how many parties start to a mediation, you generally have 4, 5, 6 people. But the key decision maker is the most important person. One of those little jokes that we in mediation land like. As you can see, unlikely to settle if that's going to be the attitude. Very often you start a day like that, and by the end you actually have an agreement. These are the various ways we're now pushing towards mediation through EU law, through judicial support and rules of court. The success rate in mediation is really quite remarkable. For the number of cases that get to mediation, from the stats that we have at this stage, it would suggest that 3 out of 4 cases settle. And the cost savings are immense. In any large commercial dispute that you're likely to get involved in, construction dispute, you're generally talking about hundreds of thousands of euro, maybe millions of euro. And so therefore, there's a lot at stake. Cases of that nature, when they get to court, take a long time. Witnesses have to be examined, have to be cross-examined. Expert witnesses cost a lot of money. They're there for the whole day. Very often they're there for the whole week, or the 2 weeks, or 3 weeks. And it isn't much cheaper in arbitration. In fact, our statistics suggest that arbitration is even more expensive. So there's a great success rate and a significant costings. So money, time, and as I said, business relationships. Here are just some stats in relation to what the organisations need to look at. Any organisation worth its salt in this country that's been involved in something like this particular summit does risk assessment. The risk assessment and the issue of mediation is a key ingredient in that. This is very boring, but it's very much the cost of the savings of litigation in the various EU. We are an expensive country to litigate, although I do question some of these stats. They arise out of a summary summons set of proceedings. But nonetheless, you can see that we are high in terms of time, and we're pretty high when it comes to cost as well. And there's a sample of the litigation costs and times that can occur. I go back to what happens in a mediation. You can settle the case. If a dispute arises, you can settle the case once you've set aside time, put in a little bit of effort into preparing the papers. You can settle it in a matter of days or weeks. And again, the number of days and costs wasted. Litigation costs to trial, various claims that set out there, and that's the big thing that I want to keep saying. The usage of it is minimal still in this jurisdiction. It's growing everywhere else, but the absolute success rate is 75%. So of the cases that get to mediation, 75% of them settle either on the day or within days or weeks thereafter. That's a remarkable success rate, where the parties have agreed to settle their cases. So, what do you do to prevent badly managed conflict? Audit your conflicts, train your managers in relation to effective control management, develop mediation resources, systemize your approach, and evaluate what you're doing. And these are on the legal department side, the sensible steps that should be taken. The basis of mediation started in the construction industry. It started out of the Big Dig in Chicago, where they were actually settling cases whilst they were digging. Very often they had dispute resolution rooms in the various companies, settling the cases whilst matters were continuing, which allowed, of course, for continued business relationships. They're the cost savings that we think can be achieved in terms of both litigation time, managers' time, work time, etc. And they are absolutely amazing. And that's pretty much it. This is the last slide. Can you see it? Okay, you can see it. Okay, some people have seen it before. It's a very attractive Parisian lady. The old hag, on the other hand, and sometimes I even miss the old hag. Yes, there's the old hag. There's the nose and the chin. So it's only a question of how you look at it. Okay? So thank you very much. I hope you enjoy the conference. I think I've come in on time, have I? Absolutely spot on. Okay, it's up to the next speakers to try and do it as well. All right, thanks very much. Okay.